Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day as always. And we are here with a Supreme Court decision came out today dealing with the copyright of law itself. Is law itself subject to copyright? This is apparently a question that the Supreme Court was answering. In this case, it came down today in the case of Georgia versus Public Resources. We're going to read this decision, including its dissents. Read the whole thing. It's only like 39 pages long for all the opinions. So, as far as Supreme Court decisions go, relatively short, or at least manageable. So we're going to be reading the whole thing and seeing what it has to teach us. And then bonus time, later today, we're going to be having a stream on the New York Pistol Rifle Association case, because that was decided. Yes, I was right. It was moot. But there was commentary, like 40 pages of commentary. So we're going to be reading that, spending some time with this later today. That's going to be fun. But you'll have to anticipate that. Right now we're talking about copyright law. So if we came to talk about firearms, you can, but, we're talking about copyright law. All right, so I'll give you a brief rundown of what the state of Georgia was trying to do and what the situation was before we get into the opinion. So the state of Georgia, in its official laws, has annotations. And Georgia, in its wisdom, has said that the annotated version of its law is the official version of its law. So what are annotations? Well, they are things added by whomever to describe the law. Usually, they go to significant court cases, or sometimes will refer to prior versions of the law if that's significant, and particularly important administrative decisions. Basically, it says all the major places that you'd go to understand that piece of law. So it's very, very helpful, when you're trying to interpret law. And a lot of private companies do this, most notably Lexis and Westlaw do it for their databases. So if you go in and you go look at a law, it'll be annotated so you can see on the online version even more than that, like all the law reviews that talk about it, just basically anything that's legal commentary that has discussed that ever, you can go read everything. And so it gives you a good place to read about that. So Georgia wanted to have annotations of its law, and it wanted them to be official. So it did that. So it contracted with Lexis to produce annotations for it, to annotate its law, to describe it as part of the official law. And then they made that version itself official. So as far as Georgia is concerned, the annotations, although not law, are the official law. They are not law in so much as they don't have operative effect. You can't be charged with a footnote, but they are part of the law as far as Georgia is concerned. You get all that? Great. So the question was, are those annotations also copyrighted? Because what Public Resource wanted to do was make the entire version of the law, including the annotations, which, remind you, are the official version of the law, public, for free, without charging people for it. And, Georgia was unhappy about this, and that was the fight. I had predicted this was going to be 9-0. I lost that fight. It's 5-4, but it is not the 5-4 you are expecting. So here's the vote breakdown. Roberts writes the opinion, in which Sotomayor, Kagan, Gorsuch, and Kavanaugh join. And in dissent would be Thomas, Breyer, Ginsburg, and Alito. Ooh, so we got a non-traditional 5-4. It's not the 5-4 that you were expecting. So, in the majority from the conservative wing, we got Roberts, Kavanaugh, and Gorsuch. And from the liberal wing, we've got Sotomayor and Kagan. And in dissent, from the conservative wing, we've got Thomas and Alito. And from the liberal wing, Ginsburg and Breyer. I just report what it is. We're going to read it and try to understand why, I guess. That's going to be fun. Yeah, that's what happened. All right, so we're going to read this and try to figure out what's going on. All right, let's get started with that. What is up with the Supreme Court now? Nothing's up with the Supreme Court right now. Nothing in particular is up with the Supreme Court right now. If it is, they tend to issue decisions. Well, before we get into the decision, we'll talk a little bit about the Supreme Court. Why not? There's nothing in particular that's up with the Supreme Court right now. So in a normal year, right, the Supreme Court meets from the first Monday of October until the last day of June. That's the Supreme Court session. That's when they're meeting, right? The first Monday of October to the last day of June. That's their time frame they meet. All right. And they hear cases throughout that whole time, and they release opinions all that whole time. But by matter of practice, it seems that more significant cases are heard later, and they're certainly decided later. Now you could come up with a whole bunch of reasons that it is. They need more time to look at it, need more time to reason it. They need more time to flush it out, whatever. But it does tend to be the case as you get closer and closer to the first day of July that more significant cases come out. So they've been deciding cases, and cases have been coming out, since December. But and we've certainly covered cases, but they're coming out with more significant cases because that's typical. So there's nothing unusual about that. The only thing unusual, of course, is we're going to start having oral arguments online or something. But that's next week's problem. So we'll deal with that next week and try to figure out what that is. But in terms of like the release schedule, I don't know, nothing particularly significant. All right, great. Let's read the opinion. Let's read the opinion of the court from Chief Justice Roberts. The Copyright Act grants potent, decades-long monopolies. Is it like Life Plus 90? Or is it Life Plus 90 these days? I kind of forgot. Yeah, it's a long time. Protection for original works of authorship. The question in this case is whether the protection extends to the annotations contained in Georgia's official annotated code. We hold it does not, which somehow we only have 5 votes for, I don't know. But yeah, over a century ago, we recognized a limitation on copyright protection for certain government work product, rooted in the Copyrights Act authorship requirement. Under what has been dubbed the government edicts doctrine, officials empowered to speak with the force of law cannot be the authors, and therefore cannot be the copyrights of the works they create in the course of their official duties. All right, so one of the things that you're talking about there is like, who is the author, right? Because it only protects works of authors. So who is the author? Right? And we've talked a lot about this, we talked about this most recently in my Sunday batch recording session that we did. So those of you who are here on Sunday will remember when we talked about public speech versus private speech, when a person is speaking in a government role versus a non-government role. We covered that. For the rest of you, you won't see that for like 2 weeks. But for those of you who were here yesterday and learned about this is another aspect of that, right? A government official is writing a document. Okay, who is writing the document? Is that person or is it the government? And so what they say here is they say, well, if it's being written by a person in their official capacity as a government actor, it's not their speech, right? It's not their speech. They may be the ones writing the words down, but it's not their speech. It's the government's speech. And so it is work of the government. And so they can't get copyright protection because it wasn't their words. Okay? That's what it's talking about. We have previously explained this doctrine to hold that non-binding explanatory legal materials are not copyrightable when created by judges who possess the authority to interpret the law. So, if these were annotations by judges, they're not. So basically, if it's dicta, it's not copyrighted. So, because you could try to distinguish, and that would be hilarious if you tried, but you could try to distinguish like the parts of an opinion that are actually legally binding from those are not, and say that the parts that are legally not binding are not actually works of the government, because I guess in some sense they're not, because they're not actually legally binding. So that'd be hilarious. We have Supreme Court opinions with random footnotes that you can't read because they're still works of the person who wrote them. That'd be hilarious, but we decided not to do that because, that'd be really stupid. So thank this all for not being really stupid. That's always a plus. We now recognize the same logic applies to the non-binding explanatory materials created by a legislative body with authority to make law. Same thing we just said. If judges are writing it, it's their work. If it's a legislature that's writing it, it's also their work. Explanatory notes, actual text, it's all equally good. So that's fine. Great. Because Georgia's annotations are authored by an arm of the legislature in the course of its legislative duties, the government edicts doctrines puts them outside copyright protection. Works for me. Works for me. The state of Georgia has one official code, the Official Code of Georgia Annotated, or the OCGA. The first page of each volume of this law boasts the state's official seal, as you would expect, and announced to the readers that it's published under the authority of the state, which, is probably a good thing when it's the laws of the state that is published with the authority of the state. That sounds like a good idea. The law includes every text of every statute, like, you would expect, as well as various non-binding supplemental materials. At issue in this case is a set of annotations that appear beneath each statutory provision. The annotations generally include summaries of judicial decisions applying a general provision, summaries of any pertinent opinions of the state attorney general. I did leave that out in my earlier description of these things. And the opinions of the state attorney general are usually considered pretty, it depends on your state, your mileage may vary. But in most states, the opinion of the state attorney general carries quite a bit of weight in terms of what the law is. So like when the state, it's not obviously the final word because it's an executive official, but in most states, if the attorney general of the state says this law means this, like most states and most courts kind of let that be if they can. It's taken as pretty important. So, state attorney general, and they can be relied on by people, and, for a lot of good reasons, There's a lot of clarifications that the state attorneys generals can do, and attorneys general, I actually said that right, state attorneys general can do, and it can really be helpful. So they're a really good place to look at things. And a list of related law review articles and similar reference materials. In addition, the annotations often include editor's notes that provide information about the origins of the statutory text, such as whether it derives from a particular judicial decision. So does this come from a judicial decision, or resembles older provisions? So I was telling you about this, right? So you have some track changes, basically, go to some older versions, tell you where the laws come from, changes, tells you how to read the law. It's good stuff. The law is assembled by a state entity called the Code Revision Commission. In 1977, the Georgia legislature established the commission to recodify the Georgia law for the first time in decades. Yeah, this was something a lot of states were doing around this time period, because a lot of, as amazing as this might be, and this may or may not be surprising to you, depending on, what you think, but most of the law was not like codified in like one book, in like one code. That's a relatively modern phenomenon that happened in a lot of these states around this time period, more or less. So before this time period, like the laws were not like put in like a chapter, verse sequence, like that you see numbered in a book. Like all these laws were just kind of like all over the place. They're just like, they weren't like consolidated anywhere. They weren't codified anywhere. So it was a big pain in the ass. So around this time, 1970s, a lot of states, including Georgia, kind of decided this was dumb. And they decided to go on a project of, what would be really convenient? What if, here's an idea. What if we put all the laws in one place so people could find them? That sounds like that might be a good idea. Let's do that. And so, yeah, around this time period, a lot of states started doing this and put a lot of their stuff on the books that, weren't actually on books before. They were in various parchments scattered around the land. So, yeah, that's a thing that happened around the 1970s. And this, yeah. The commission was and remains tasked with the consolidating disparate bills into a single code for reenactment by the legislature. Yeah, so again, this is going historical, but this is the way things were pre-circa 1970s-esque. Okay, the legislature would just write bills about whatever. They would pass bills and write bills, and they would just like be in the ether. And then the last state said, it would be a really good idea. What if we took all these kind of bills? They're like vaguely about the same thing. And here's an idea. What if we took these bills that are like kind of about the same subject matter and we put them under like a common title or a common chapter that, like they're related to the same thing? What if we put them in one place in like a book with chapters and titles, and people could look at them and they'd have all the related laws in one place? Wouldn't that be neat? It would be neat. So let's do that. So the state of Georgia and like a lot of other states said, hey, would you do me a solid? Would you go through like the history of all the laws we've ever passed in the history of time? And would you figure out what laws relate to what other laws? And would you put them into a numbered sequence? And then would you represent them back to us so that we can reenact them all in one nice sequence that everything flows from everything else, so that like, people can find them? That'd be super helpful. And that's the thing that happened around this time period, yeah. A majority of the commission's 15 members must be members of the Georgia Senate or House of Representatives. The commission receives funding through appropriations provided by the legislature branch for the state of government, and is staffed by the Office of Legislative Counsel, which is obligated by the statute to provide services for the legislative branch of government. Under the Georgia Constitution, the commission's roles in compiling the statutory text and accompanying annotations falls within the sphere of legislative authority, which, how could it not? Because, what are the laws, and wouldn't it be cool if they all existed in one place? And let's do that. Yeah, that's a good thing. You want to get even freakier? I'm going to freak a lot of people out. This is going to be a good one. This is going to be a good one. Okay. This is obscure legal knowledge. This is obscure legal knowledge I'm now going to share with you. Ooh, all right. Prepare yourselves. The United States Code. We all love the United States Code, right? Because it too, like most of these state laws, has titles and chapters and acts and all that rest of that stuff, right? All right. So you go turn to a page of the U.S. Code, whatever code you want to look at. Maybe this one for it, maybe Title 17, U.S.C. 102, because you want to know what copyright law is, right? So you go to 17 U.S. Code 102, and it tells you something. Here's the question. Here's your question for you. Is what you just read the law or not? I'll give you a second to think about it. Yeah? Okay. Depends. It depends. There are a couple titles of the U.S. Code, and I know they're written down somewhere, but I can't tell you off the top of my head what they are. But there is a couple titles of the U.S. Code where the U.S. Code says that the way it's printed in the U.S. Code is the authoritative version. But not all of them. In fact, not most of them. There's only like 5 or 6, because they too have the same problem. They've too been trying to consolidate the law to varying degrees of effect. And, it's taken a while. So there are like, 6 or 8 of the titles of the U.S. Code where the law says that those titles as they're printed in the U.S. Code, that is the law. However, in the other ones, it depends. Is it actually what Congress passed or not? See, that's the whole deal, right? Because if it's the ones that have been recodified and enacted, then it doesn't matter what Congress passed the first time. If it's in U.S. Code, then that's the law. It doesn't matter what Congress actually wrote. If it's in the U.S. Code, that's the version. However, in the other ones, it does matter what Congress wrote. So you actually have to go back to the original bill and look. And if it's not translated correctly, or if they rest something out, then the one that's in the U.S. Code isn't the law. The one that's in the bill is the law. Good times. It thankfully doesn't come up very much, but it's one of those little details that we love. Yeah. So it's Title 17 of the U.S. Code being whatever the word is. I don't even actually know what the official word is. We'll call it consecrated, because I can't remember what the official word is. But is Title 7 of the U.S. Code actually like the final version of copyright law? I don't know. That's a good question. I'd have to figure it out. Let's press on. Each year, the Commission submits its proposed statutory text and accompanying annotation to the legislature for approval. The legislature then votes to do 3 things: enact the statutory provision of the codification of Georgia's laws, merge the statutory provision with the annotations, and publish the final version by the authoritative state as the official code of Georgia Annotative. The annotations in the current law were prepared in the first instance by Matthew Bender, a division of LexisNexis, pursuant to a work-for-hire agreement. So work for hire, we all know, right? I'm paying you to do something for me, but that makes me the author. No problem. The agreement between Lexis and the Commission states that any copyright in this vests in the state of Georgia, acting through the Commission. Lexis and its arms of researchers perform the lion's share of the work in drafting the annotations. Lexis does this all the time. They do it for their own private databases too. It's one of the services they offer. It's one of the reasons like LexisNexis and Westlaw are really good services, because they do all these annotations and collections. So they're very, very helpful as legal databases. They save an immense amount of time. So it's one of the reasons that they cost so much. And, it takes a lot of time and effort to put them together too. So that's also one of the reasons they cost so much. But, that's one of the things they do. Yeah. But the Commission supervises the work and specifies what annotations must include in exacting detail. Under the agreement, Lexis enjoys the exclusive rights to publish, distribute, and sell this part of the law. In exchange, Lexis has agreed to limit its price it may charge and to make an unannotated version available for free. A hard copy of the law currently retails for $412, which, if you want a hard copy of the law, $412 actually doesn't sound that bad. Because, it's all the law and all the annotations, and it's going to take some space. So, $412 for a complete hardbound copy of the law sounds pretty good, actually. Well, what if you don't want a hardbound copy? Because, who uses hardbound copies anymore? PublicResource.org is a non-for-profit organization that aims to facilitate public access to government records and legal materials. Without permission, the group published a digital version of the law on its various websites where it could be downloaded by the public without charge. The group also distributed copies of the law to various organizations and Georgia officials. So, yeah, this is where the rubber meets the road. A private organization is publishing the law, and that's bad. Okay. We'll try not to think too hard about the potential copyright infringement issues on me reading a Supreme Court opinion. Because I'm making this. I'm a private actor republishing the law. Ooh. Ooh. In response, the Commission sent the organization several cease and desist letters, insisting that its actions constitute unlawful infringement. When the organization refused to halt its activities, the Commission sued on behalf of the Georgia legislature and the state of Georgia for copyright infringement. The fact you're suing in the name of the state is also pretty hilarious. The Commission limited its assertion of the copyright to the annotations because, it did not claim copyright in the statutory text or numbering. The group counterclaimed seeking declaratory judgment that the entirety of it, including the annotations, are public domain. Which, I would think they are, but yeah. The district court sided with the Commission. The court acknowledged the annotations in the law presented an unusual case because most official codes are not annotated and most official codes are not official. Right. So, fair enough. Yeah, this is very unusual what Georgia has done. But, Georgia is the master of its own law, and so it's decided to do this. Most versions published by the states do not include annotations. Annotations are not produced by the state. Not for least reasons. It's a pain in the ass because, it requires a lot of effort to do. But, they don't do it. If you want annotations, you go to a private group, like Lexis or Westlaw would be your traditional ones to do, because they're really good. And which one you want between Lexis or Westlaw, as far as I'm concerned, they're equally good, and it's more an issue of comfort. They're both perfectly fine. Either one's fine. But that's normally who you would go to. So Georgia decides it wants to actually make its own annotations. That's unusual. And what's even more unusual is that it made its annotated version the official version of law. So one wonders if Georgia might make it not the official version of law. That would be hilarious. Will Georgia decide to not make it the official version of law? Now, that won't help them for the version as it exists today. So it would only help them for any annotations going forward. But will Georgia be so petty as to change it so that the annotated version is not the official version anymore? Who wants to take bets on that? Who wants to take bets on whether Georgia is so petty that it decides, the annotated version isn't the official version anymore, so any new annotations aren't able to be open? Who wants to take bets on whether that's going to happen? Yeah, okay. The court acknowledged the annotations in the code present an unusual case. Okay, we discussed that. But ultimately, the court concluded the annotations were eligible for copyright because they were not enacted into law and lacked the force of law. Yeah, this is where we run out of words to describe things because we're using the same word in multiple different senses and it gets a little bit confusing. Okay, the annotations are not law. Nevertheless, they're part of the law. If that sounds confusing, I don't blame you because I don't have any other words to describe it. They don't have the force of law. You can't be charged with them. They are not binding on you. Nevertheless, they are part of the official law, even though they're not law. I don't have any other words. It gets a little confusing. I need different words, man. In light of the conclusion, the court granted partial summary judgment to the commission and entered permanent injunction requiring the organization to cease its distribution. Fine. The 11th Circuit reversed. The court began by reviewing 3 19th century cases in which we articulated the government edicts doctrine. The court understood those cases to establish a rule based on interpretation of the statutory term author, that works created by courts in the performance of their official duties did not belong to the judges, but instead fell into the public domain, because they are not works of the judge. Even though they're written by the judge, they're not works of the judge. The judge is speaking for the government or for the law, depending on your point of view, but yeah. In the court's view, that rule derives from first principles about the nature of law and democracy. In democracy, the court reasoned, the people are constructive authors of the law. So that too, right? So that's also a nice little trick of U.S. law in particular, right? Because ultimately, who is the law? Who is ultimately the ultimate authority of law? And in the U.S. system, as far as we're concerned, the ultimate authority of the law is the people in their collective will. It's nice, right? That's what we fought a war over and a revolution over. And if you read the Constitution, it's the first 3 words of the Constitution: we the people. We the people. So the people in their collective will are sovereign. And they are the ones that have created everything. So when a judge speaks, he speaks ultimately under the authority of the people. So the people themselves are the authors of the work. And therefore there's not copyright. Because it wasn't authored by a person. It was authored by the people. It's a pretty romantic idea, but I like it quite a lot. Because, I'm a sucker for that kind of thing. The court therefore deemed the ultimate inquiry to be whether a work is attributable to this constructive authorship of the people, collective. The court identified 3 factors to guide the inquiry: the identity of the public official who created the work, the nature of the work, and the process by which the work was produced. The court found that each of these factors cut in favor of treatment of the laws, annotations, as government edicts authored by the people. Yeah, so who's actually writing this? Who's actually writing it? That's the ultimate question. Who's actually writing these things, as far as the Court of Appeals was concerned? And they said the people in their collective will are the ultimate authors of this thing. Yeah. And therefore rejected the commission's assertion of copyright, vacated the injunction, and directed that it be entered for the private organization. We grant certiorari. All right, so now the Supreme Court, having gone through the history of all this and how we got to here, now we begin, part 1 was history, background. Part 2, we begin with, this is now the law. So we've discussed how we got here. Let's discuss what the law is now. All right, great. We hold the annotations in this are ineligible for copyright, though the reasons are distinct from those relied on the Court of Appeals. Okay, so they say different reasons. Fine, we'll see what those are. A careful examination of government edicts precedent reveals a straightforward rule based on the identity of the author. Under the government's edicts doctrine, judges, and we confirm legislators, may not be considered the authors of works they produce in the course of their official duties as judges and legislators. That rule applies regardless of whether a given material carries the force of law. It applies to annotations here because they're authored by an arm of the legislature in course of its official duty. So it looks like the Supreme Court is getting slightly less romantic with this. So, okay, well, that's fine. But either way, judges and legislators are not authors. Whether it's official or not doesn't matter. Whether it's dicta or whatever, it doesn't matter. If it's published under the seal of the government, it is the work of the government. And, so no copyright for you. Good. We begin with the precedent, which, is not quite originalist. But then again, this was written by Roberts, not Thomas. So I don't know if Thomas has an originalist objection. And that'll be hilarious if he does. And he probably does. He probably does have an originalist objection. If I had to guess what Thomas is going to write, I'm gonna guess that he's going to say something like the Copyright Act in its terminology entitles 17 U.S.C. 105 says works of the U.S. government are not copyrighted, but it doesn't say anything about state governments. And so he's going to say that copyright in its conception allows Congress to recognize anyone as the author and or not. And so they have chosen to not give copyright authorship to U.S. federal officials, but they haven't taken away from state officials. And therefore, under originalist grounds, it doesn't matter whether it's a state judge, state legislature, or anything, it can be copyrighted because it's within the scope of Article 1, Section 8, Clause 8. That is my back of the envelope guess for what Thomas is going to write. We're going to see when we get there. We haven't gone that far, but we're being written by Roberts now. So Roberts wants to start with precedent, not originalism. Okay, fine. The government sees doctrine traces back to a trio of cases decided in the 19th century. In this court's first copyright case, the court's third reporter of decisions, Wheaton, sued the fourth. You see what happened there? Okay. The court's reporter of decisions, like the guy who compiles it, Wheaton, sues Peters. All right. In Wheaton's views, the opinions must have belonged to someone because they are new and original and much more elaborate than the law or custom required. Wheaton argued the justice were the authors and assigned him their ownership interest to him through a tacit gift. Cute. The court unanimously rejected that argument, concluding that no reporter has or can have any copyright in written opinions delivered by this court, and that judges therefore cannot confer on any reporter such a right. Yeah, so one of the early reporters, which is an official position, okay, at this point in history. You know, if you ever read like really old Supreme Court cases, sometimes you'll see them in a different citation format than you're used to, because modern Supreme Court cases are number U.S. number, right? And you can refer to old cases that way too. You can refer to old cases that way. But if you go back to the early parts of the U.S. history, the cases are not usually referred to that way. They're usually referred to by the person's name. So you'll see something like 1 Cronch, 42, or 5 Wheaton, whatever, because they're referred to by the reporter's name rather than U.S. So that's what we're talking about. Basically this clerk position, who's the reporter, has said, I have copyright over the decisions you wrote. It's a bold move, Con. Let's see how it works out for him. Not well. Okay, great. And that conclusion apparently seems too obvious to adorn with further explanation, but the court provided one a half-century later in Banks versus Manchester. The case concerns whether Wheaton's state court counterpart, the official reporter of the Ohio Supreme Court, held a copyright in judge's opinion and several non-binding exploratory materials prepared by the judges. The court concluded that he did not, explain the judge, who in his judicial capacity prepares an opinion or decision, statement of the case, and syllabus or headnote, cannot be regarded as an author or proprietor in the sense of a Copyright Act. Who won? The people who want to make the law public. PRO won. Pursuant to a judicial consensus dating back to Wheaton, judges could not assert copyright in whatever works they perform as capacities as judges. Rather, the whole work done by judges constitutes the authentic exposition and interpretation of the law, which binding every citizen is free publication for all. Very romantic and very exciting. In a companion case decided later that term, Callaghan versus Myers, the court identified an important limiting principle. As in Wheaton and Banks, the court rejected the claim that an official reporter held a copyright interest in the judge's opinion, but, resolving an issue not addressed, the court upheld the reporter's copyright in several explanatory materials the reporter had created himself: headnotes, syllabus, table of contents, and the like. Yeah, so this is, again, this is not like something that was traditional. It's something that has become more common, and thank God it makes everyone's life so much easier by having all these things. And so this person was creating them, and they say, well, to the extent you were doing that, you weren't doing, work for us. You were doing your own work, so you can have copyright in that, which is fine because it was a work of his own labor. Now, you could go the other way, obviously, and say, it doesn't get it because of his role, which is what you'd say now, because 17107 or 17105 says that no copyrights in a government official, right? But the logic of it at least makes some sense. So, okay. Although these works mirror the judge-made materials in Banks, they came from an author who had no authority to speak. Okay. Because the reporter was not a judge, he is free to obtain copyright for the materials that were a result of his own labor. These cases establish a straightforward rule. Because judges are vested with authority to make and interpret the law, they cannot be the author of the works they prepare in the discharge of their duties. This rule applies to both the binding works, such as opinions, and non-binding works, such as headnotes and syllabus and dicta and all that great stuff. It does not, however, to prepare to works created by a government official or private parties who lack authority to make or interpret the law, such as a court reporter. As is a matter of constitutional law they're talking about. As a matter of statutory law, your mileage will still vary today. The animating principle behind this rule is that no one can own the law. Good idea. Every citizen is presumed to know the law, and it needs no argument to show that all should have free access to its contents. Yeah, it's a very funny thing because, like, if we want to take the proposition that ignorance of the law is not an excuse, then, it would probably be a good thing if people had access to the law. If we say you have ignorance is no excuse, and by the way, you can't have access to the law, that's a little bit hard to maintain both those positions at the same time. So maybe we should give people access to the law. Seems like a good idea. Our cases give effort to the principle in the copyright context through construction of the statutory term author. Rather than attempting to catalog the materials that constitute the law, the doctrine bars the officials responsible for creating the law being considered the authors of whatever work they perform. Because these officials are generally empowered to make and interpret the law, the whole work is deemed to be the part of the authentic expression and interpretation of law must be free for all. If judges acting as judges cannot be authors because their authority to make and interpret law, it follows that legislatures acting as legislators cannot be either. Courts have long understood the government edicts doctrine to apply to legislative materials. Before Trump tries to claim copyright interest in an executive order. Or I guess annotations there too, or whatever. Yeah, okay. In before that. Moreover, just as doctrine applies to whatever works judges perform as in their capacity as judges, it applies to whatever works legislatures perform in their capacity as legislators. That, of course, includes final legislation, but also includes the explanatory and process materials legislatures use and create in the discharge of their duties. In the same way, a judge cannot be the author of a headnote or syllabus, legislatures cannot be the authors of their floor statements, committee reports, or proposals. That material is part of the whole work done, so they must be free publication for all. Under our precedent, therefore, the copyright does not vest in works that are created by judges or legislators in the course of their official duties. Fantastic. So we got that covered. Anything created by a judicial branch or a legislative branch is not copyrightable. Executive branch, I guess, is still open or something. I don't know. Applying that framework, judges' annotations are not copyrightable. The first step is to examine whether a purported author qualifies as a legislator. As we explained, the annotations were prepared in the first instance by a private company, Lexis, who would be a good company to hire to do this, pursuant to the work hire agreement for George's quoted revision. The Copyright Act therefore deems the commission the sole author of the work. Although Lexis expends considerable effort preparing the annotations for the purpose of copyright, that labor redounds to the commission as a statutory author. Georgia agrees that the author is the commission. The commission is not identical to Georgia's legislatures, but functions as an arm for the purpose of producing annotations. So yeah, it's not the exact same thing as the legislature, but it's part of it. It's essentially a committee, but not exactly because there are non-legislative members sitting on it too. But it's it's authorized by the legislature to do a legislative purpose, so it's legislature enough. The commission is created by legislature for the legislature and consists largely of legislature. The commission receives funding and staff designated by law for the legislative branch. Significantly, the annotations the commission creates are approved by the legislature before being merged with statutory text and published in the official code alongside the text and legislature's direction. If there any doubt between the link between the commission and the legislature, the Georgia Supreme Court has dispelled it by holding that under the Georgia Constitution, the work of the commission, that is, selecting a publisher and contracting for and supervising the codification of law, including the interpretations, is within the sphere of the legislative authority. That holding is not limited to the commission's role in codifying the text. The commission's legislative authority specifically includes codification of court interpretations of the state's laws. Okay. So one of the things this commission can also do is codify court decisions as part of the law, which is cool. Court made a decision and you want to actually change the law to reflect the court decision. That's kind of cool. So that is a neat thing that helps save a little bit of time. But yeah, so that's one of the things they can do too. Thus, as a matter of law, the commission wields legislative authority when it works with Lexis to produce these annotations. All this shows the commission serves as an extension of the legislature in preparing and publishing the annotations. It helps to explain why the commission brought the suit asserting copyright and annotations on behalf of and for the benefit of the legislature. The second step is to determine whether the commission creates the annotation in the discharges of legislative duties. It does. Although the annotations are not enacted through law, through bicameralism and presentment, the commission's preparations of annotations under Georgia law is an act of legislative authority. So, it's not done the same way a thing becomes a law, because it's not law, even though it's part of the law. So it doesn't have to go through that process, yeah. The annotations provide commentary and resources that the legislature has deemed relevant to understanding the law. Georgia and Justice Ginsburg emphasized that annotations do not purport to provide authoritative explanations of the law, and largely summarize other materials, such as judicial decisions and law review articles. Yeah, that's what you would expect. Annotations are not authoritative. They are a very, very helpful guide to understand the law. That is not the law, though. They're part of the law. They're not the law. They're explanations of the law. They're not the law. But they're very helpful. So, yeah, that makes sense. But that does not take them outside the legislative duty of the commission legislation. Just as we held the statements of a case and syllabus or headnote are prepared by judges fall within the works they perform, so too the annotations prepared by these legislatures fall within this capacity. In light of the commission's role as an adjunct to the legislature and the fact the commission's authors the annotations in the course of legislative responsibilities, the annotations of the code fall within the government's edicts doctrine and are not copyrightable. Georgia resists this conclusion on two grounds. At the outset, Georgia advances two arguments for why, in its view, excluding the annotations from copyright provisions conflicts with the Copyright Act. Both are unavailing. First, Georgia notes that Section 101 of the Act specifically lists annotations among the works eligible for copyright protection. Yes, that's true. But the provision only refers to annotations which represent a original work of authorship. Yeah. So annotations are copyrightable, but, it has to be done by a person, and these aren't people within the scope of this meaning. The whole point of the government's edicts doctrines is that judges and legislatures cannot serve as authors when they produce works in their official capacity. While the reference to annotations in 101 may help to explain why supplementary explanatory materials are copyrightable when prepared by a private party, which, Lexis is endlessly grateful for, because otherwise all those annotations they produce would be free for all, and that's like a major part of their business. And again, it takes a lot of effort, time, resources, very professional staff. I mean, it's a huge undertaking. So, they're very grateful for that. That's for damn sure. It does not speak to whether the same materials are copyrightable when they're prepared by a judge or legislature. That's fair. In the same way that judicial materials are ineligible for protection even though the work qualifies as a literary work, legislative materials are ineligible for protection if they happen to fit this description of annotations. Yeah, fair enough. The opinions themselves are literary work, but they're not copyrightable, so neither are the annotations. That makes sense to me. Second, Georgia draws a negative inference from the fact that the Act excludes from copyright protection works prepared by officers of the United States. Yeah, I know this is probably this is what I expect Justice Thomas is going to pick up on too. Right, 17 U.S.C. 105 excludes from copyright anything prepared by a government official in their official capacity, but not for states, which incidentally, I think, why? But that's what it says. So yeah, they say there's a negative implication there. And, Georgia has a really good point. Georgia actually has a really good point here. Now, that Georgia would have a copyright interest in some things it does, I don't think we necessarily have a major objection to that, right? So if Georgia wanted to put together, a novel or, a guide to the city or some stuff, right? There's a lot of things we could figure that, would not necessarily, maybe a map. There's a lot of things that the state might want to produce that would be copyrightable, and we wouldn't necessarily have a major objection to that. But we're talking about the law, which is a little bit different, right? So that the state of Georgia can own copyright, should they? I don't know. I mean, they can. If the United States government as a whole produces maps or guides or whatever, well, that doesn't get copyright. So why should the state? I don't know. But they can and do, and maybe that makes sense. I don't know, but it's what it is. So, it is a little bit of difference there. But the bar in copyright for federal works sweeps much broader than the government edicts doctrine does. That's true, because the bar applies to works created by all federal officials or employees without regard to the nature of the position or scope of their authority. So it is a lot broader, and that's a very fair point. Whatever policy reasons might justify the federal government's decision to forfeit its own protection for its own proprietary works, that rule does not suggest an intent to displace much narrower government edicts doctrine with respect to the states. Yeah, so that's really, really fair. And that's a very good point, a very good counter by this opinion, right? So it's sweeping much wider. So basically the analysis here is like, even if 17 U.S.C. 105 didn't exist, like there would still be whatever government works within the government's edicts doctrine would not be protectable. All right. But, the Congress went even further than that. So they said anything produced by a government employee as part of its official job is not subject to copyright. That's what they said. So that's wider. So that makes sense. And therefore, the negative implication doesn't really hold. Good answer. Good job, Justice Roberts. That doctrine does not apply to non-law-making officials, leaving states free to assert copyright in the vast majority of expressive works, such as those created by their universities. And here, be careful, we're talking about public universities, because public universities are works agents of the state. So again, we're talking about like the University of Georgia or Georgia Tech or like a lot of other public schools who is producing work. So they might have some interest there. Okay, that's what things we're talking about. So they're created by the public universities, public libraries, public tourism offices, and so forth. More generally, Georgia suggests that we should resist applying our government's ease precedent to these annotations because this 19th century forebears interpreted statutory text authored by reference to public policy, an approach Georgia believes is incongruous with a modern era of statutory protection. Okay. But we are particularly reluctant to disrupt precedents interpreting language that Congress has since reenacted. That's also like an interesting doctrine of legal thinking. So if a court interprets a particular piece of statute, right, the Congress or whoever it is, depending on what the legislature is in question, but they can always change it by legislation, right? They can always change it. I mean, if it's a statutory issue, not constitutional, which a lot of these decisions are. So if a court is interpreting a statute, the Congress or legislature can change it. So if they leave it alone, what does that suggest? Not much. But if the legislature at some point reenacts the exact same language, because, they're amending something else, so they're writing a bill, and what you usually do is, usually underline the parts you're adding, strike through the parts you're not, right? So you're reenacting the whole thing, and you kept that same language. So one of the things that has traditionally been understood to mean is that the legislature is adopting the judicial interpretation of the language, because it's the same language. It's been interpreted by the court. They could change it, but they adopted the exact same language. So one of the things it says is, well, we think that because they could have done something different but didn't, and chose the exact same language, that means that they adopted, ratified, incorporated our decision as part of it, right? So if the language says A, the court says something later, and then the legislature comes back with it, and then you say, well, that decision was wrong. You say, but they validated us, so it must be right, because they would have changed this if it wasn't, and they didn't. So it must have been right. So we're not going to revisit our own precedent, because when the legislature reenacted this language, they were relying on what we said, and they could have changed it and didn't. So they must have wanted what we did. So if we reevaluated our own precedent, we'd be undermining the legislature who reenacted the language based on our precedent. So we're not going to do that. So that's what they're talking about. As we explained last term in this Helsin healthcare case, when Congress adopts language used in an earlier act, we presume they adopted the construction given by the court and made part of the enactment, which was a much shorter way of saying what I said, but yeah. A century of cases have rooted the government edicts doctrine in the work author, and the Congress has repeatedly reused that term without abridging it. The term now carries a settled meaning, and critics of a ruling can take their objections across the street, where Congress can correct any mistakes it sees. That's very cute and a little passive-aggressive, and I like it. This word author has been reenacted. They've adopted all our meanings. And so if you're upset with us at this point, what you need to do is you need to go out the front door, walk across the street. You'll run right into Congress. Talk to them. Yeah, that's okay. Moving on from the text, Georgia invokes what it views as the official position of the Copyright Office and reflected in the compendium of the U.S. Copyright Office practices. But as Georgia concedes, the compendium is non-binding administrative manual that most merits deference under Skidmore versus Swift, which is the predecessor to Chevron. Because this is so great too. Wow. I love this so much. This is such a like small thing that, only I don't know, only I would pick up on it, but I'd pick up on it because I'm super sensitive to Chevron. All right. So Skidmore is a case I actually like. Skidmore was what we had before Chevron. Skidmore was great. Skidmore was awesome. It was wonderful and great. All right, so pay attention to what's happening, because this is a really interesting little thing that's happening here, okay? Pay attention. All right, because this is fun. All right. Georgia invokes what it views as the official position of the copyright. Should we give Matt a test? should we give Matt a test? Should we give Matt a test? That's always a good one. Oh man. Matt, why does Skidmore apply and not Chevron? Why does Skidmore apply and not Chevron? You got to know this. You got to know this, man. It's a real easy answer. That's okay, Matt. We're going to help you out, all right? All right, so moving on from the text, Georgia invokes what it views as the official position of the Copyright Office, as reflected in the compendium of the U.S. Copyright Office practices. Okay, the Copyright Office has a compendium of its practices, okay? All right? But, as Georgia concedes, the compendium is non-binding administrative manual that, at most, merits deference under Skidmore. Why Skidmore, not Chevron? Dates is the wrong answer. No. Dun, 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 dun. No. Unfortunately, no. Here's the answer. The court is being a little bit loose in its language, so it was a little bit baiting Matt here. But the answer is, because although they refer to it as a non-administrative manual, the Copyright Office is not an administrative agency, because the Copyright Office is not within the executive branch. The Copyright Office is within the legislative branch. It is an arm of the Library of Congress, which is within the legislative branch. So although it looks, smells, and feels like an administrative agency, technically it's not, because it's in the legislature. Therefore, Chevron does not apply, because Chevron is a case dealing with executive agencies, and this is a legislative agency. That's the reason that Skidmore applies. Oh, yeah. That's what's going on. That means we follow it on to the extent it has the power to persuade. And see, this is why I like Skidmore so much better than Chevron. This language from Skidmore was great. Because in the long ago, in the far away, when executive branch agencies were also under Skidmore, which is what we had before Chevron, in the long ago, when they all were also bound by Skidmore, you only followed it to the ability it had the ability to persuade, which meant that it wasn't binding authority, and meant that the courts reviewed it de novo, and the courts got to interpret law. It was wonderful. It was great. It was awesome. Let's go back to Skidmore, please. Matthew asked me a question. Let me get this straight. Since it's under the branch that makes law, the rules that have less power than the one that's under executive. I mean, they're just treated differently. I mean, I don't know that it's quite that simple, Matt. It's just that they dealt with it differently. Chevron and Brand X and Auer were decisions dealing with executive agencies, and there's never been a decision dealing with legislative agencies or judicial agencies. We saw this in that case with that case in the Federal Circuit, where it was a judicial agency, right? Because they were promulgating rules as a judicial agency. And we said, oh yeah, they went up and they said, remember, because we heard that oral argument in the Federal Circuit, and they said, oh, we wouldn't apply Chevron here because it's not an executive agency. So yeah, for better or worse, it's just that all those cases have dealt with executive agencies, and no one's ever bothered to apply them to the legislative or judicial agencies. So Skidmore still applies. Skidmore was great. Let's bring back Skidmore. Make Skidmore great again. We should get some merch and say "Make Skidmore great again." We should get a "Make Skidmore great again" hat. Be awesome. Be awesome. In any event, the compendium is largely consistent with our decision. Drawing on banks, it states that as a matter of long-standing public policy, the U.S. Copyright Office will not register a government edict that has been issued by any state, local, or territorial government, including legislative enactments, judicial decisions, administrative rulings, public ordinances, or similar types of official legal materials. And under banks, what counts as... Oh, wow. I don't know that I necessarily call the Supreme Court's clerks highly qualified interns. I mean, that's a little bit demeaning. I don't know, quite use that language. They're brilliant. I met one time who had a stick up her butt, but which didn't actually surprise me, because some of the people who are the best performing are wound so tight, because that's how they got to be really, really good performing, and she was just wound so tight. It was amazing. What counts as a similar material depends on what type of officer created the material and whether the officer created the course in its official duties. The compendium goes on to observe the office may register annotations that summarize or comment upon legal materials unless annotations themselves have the force of law. But that broad statement, true of annotations created by officials such as court reporters that lack the authority to make or interpret law, does not engage with the critical issue of annotations created by the judges or legislatures in official capacities. By the way, Matt, I have to know, because I just figured this out. Is there any truth to the idea that you said it's the dates? Because the last time I gave you a pop quiz, what it turned on was the dates. And so you said, it's the dates? Because that was the answer last time? Is that what happened? I think it might be what happened, because I just realized you said, oh, it's dates. It's like, well, that was the answer last time. So you're like, oh, that's the rule. No. Poor Matt. I love you, Matt. You're great. Because the compendium does not address that question, otherwise echoes our government edicts, precedents is of little resonance here. Georgia also... the answer is not necessarily what it was the last time. Also not an answer here, because it's a difference between civil and criminal. That is also not the answer here. Just by way of teasing Matt, because Matt's a great guy. Matt's a 2L now, I think. Georgia also appeals the overall purpose of the Copyright Act to promote the creation and dissemination of creative works. Georgia submits that without copyright protection, Georgia and many other states will be unable to introduce private parties like Lexis to assist in preparing affordable annotated codes for widespread distribution. That appeal to copyright policy, however, is addressed to the wrong form. As Georgia acknowledged, it is generally for Congress, not the courts, to best decide how to pursue the Copyright Clause objectives, citing Elred, which was the case that dealt with the Copyright Extension Act, wasn't it? And whether or not that was legal, and I was like, I think that was 7-2, and I agreed with the dissent from Breyer in that one. And the principles requires adherence to principles that, when as is here, construe the statutory test and toss the ball into Congress's court for acceptance or not, as that branch licks. Turning to our government's edicts precedents, Georgia insists that they can and should be read to focus exclusively on whether a particular work has the force of law. Justice Thomas appears to endorse the same view, but the framing has multiple flaws. Most obviously, it cannot be squared with the reasoning or results of our cases, especially Banks. Banks, following Wheaton and judicial consensus it inspired, denied copyright protection to judicial opinions without accepting concurrences and dissents that have no legal force. As every judge learns the hard way, comments in a dissenting opinion about legal principles and precedents are just that, comments in a dissenting opinion. Ouch. Ouch. Yet such comments are covered by a government edicts doctrine because they come from official without authority to make and interpret the law. Well, I'd have to go back to see exactly what that railroad board case was saying, because I haven't read it. But I think it's slightly unfair. Obviously, if you don't have enough votes for it to be binding authority, it's not binding authority. But that being said, it's a little bit unfair to merely call them comments, because today's minority opinion might be tomorrow's precedent. It's happened a couple times of note, right? And perhaps most notably from Jackson's opinion, which was technically concurring in Whitney versus California, which became the basis for the entirety of First Amendment law as we now know it, was from like that one opinion from that one judge. So that's why I'm such a fan of it, because it's a little unfair to say, oh, because it doesn't have precedent, it's just mere commentary, especially if it's U.S. Supreme Court. Especially if it's U.S. Supreme Court. I think that like stuff that's dicta from the Supreme Court and comments from the Supreme Court and stuff in the minority and stuff in the dissent from the Supreme Court is not quite the same as it is in other courts. You might want to pay a little bit more attention to it. In words to the wise. Indeed, Banks went further and withheld copyright protection from headnotes and syllabus produced by judges. Surely those supplemental materials do not have the force of law, yet they're covered by this doctrine. A simple explanation is one that Banks provided. He's not, a judicial capacity. The same goes for non-binding legislative materials produced by legislative bodies acting in a legislative capacity. There's a broad array of such works ranging from floor statements to proposed statements to committee reports. Under the logic of Georgia's force of law test, states would own such materials and they could charge the public for access to them. Further, despite Georgia's and Justice Thomas's purported concern for the text of the Copyright Act, their conception of the government's edicts doctrine has less of a textual footing than traditional formulation. Ooh, fighting words. Fighting words. Oh, that's fighting words. Justice Roberts just said Justice Thomas's interpretation is less loyal to the text than his. There's going to be a row. The textual basis for this doctrine is the Act's authorship requirement, which is unsurprisingly focuses on the author. Justice Thomas urges us to dig deeper to the root of our government's edicts precedent. But in our view, the text is the root. Ooh, ouch. Oh, ow, ooh. It hurts. Yeah, Justice Thomas, since when isn't the text binding? What happened to you, man? You go into some legislative intent, man? You're not interested in text anymore? What happened to you, bro? But in our view, the court long ago interpreted the word author to exclude officials empowered to speak with force of law, and Congress has carried that meaning forward in multiple iterations of the Act. The textual foundations explains why sub-doctrines distinguishes between sub-authors who are empowered to speak with the force of law and others who are not. But the Act's reference to authorship provides no basis for Georgia's rule distinguishing between different categories of content with the distinct effects. Georgia minimizes the annotations as non-binding and non-authoritative, but the description undersells the practical significance. Imagine if a Georgia citizen interested in learning his legal rights and duties, heaven forbid that, the common person read from our holy text. Those are reserved texts for only the clergy. Common man doesn't get to read them. Just for us. If he reads the economy class version of the law available online, he will see laws requiring political candidates to pay hefty qualification fees, criminalizing broad categories of consensual sexual conduct, and exempting certain key evidence in criminal trials from standard evidentiary limitations, with no hint that important aspects of the laws has been held unconstitutional by the various courts. Meanwhile, first-class readers with access to annotations will be assured these laws are, in crucial respects, unenforceable relics that legislatures have not bothered to narrow or repeal. Good times. If everything sort of statutes and opinion were copyrightable, then states would be free to offer a whole range of premium legal works for those who can afford the extra benefit. A state could monetize an entire suite of legislative history. With today's tools, states might even launch a subscription or pay-per-law service. That's pretty horrible. That's rough. That's rough. There's no need to assume inventive or nefarious behavior for these concepts to become a reality. Unlike other forms of intellectual property, copyright protection is both instant and automatic. Which, it is, but yeah. It triggers as soon as the work is captured in a tangible form, triggered a panoply of exclusive rights that last for over a century. Yeah. It's weird. I don't know if it's weird. It's notable how much the copyright term has expired. I don't know how much trademark terms were when they first were invented. So I don't know how much the trademark terms have grown over the years. But I can tell you a trademark lasts for 10 years today. You can renew it indefinitely, but it only lasts for 10 years. You have to keep maintaining it. So a trademark lasts for 10 years but can be renewed forever as long as it's, still being used and stuff. But you actually have to do that. Patent law, when it was first invented, I can tell you that. In the original constitutional era, it was 17 years from the date of grant. And now it's 20 years from the date of filing, which in practice is the exact same term. But it does have some practical consequences that are a lot better in terms of making sure things get filed and stuff like that. So the patent term hasn't grown. They changed the measuring point in order to solve a problem, and it's for the best. And then the copyright term, when it was first invented, was 14 plus 14. So much like the trademark law today, which is 10 plus 10 plus 10 plus 10 plus 10 plus 10. That's what we mean, right? When we say that. It's 10, and it's removable for another 10, or renewable for another 10, or renewable for another 10. So you could say that way, right? So the copyright law, when it was first invented, was 14 plus 14. You could only renew it once. Now it's life plus 90. It's, gotten a little bigger. So, yeah. If Georgia was correct, then unless the state took the affirmative step of transferring its copyrights to a public domain, all of the judges and legislatures' non-binding legal works would be copyrighted, and citizens, attorneys, nonprofits, and private research companies would have to cease all copying, distributing, and display of those works or revere penalties. Some affected parties might be willing to roll the dice with potential fair use defense, but the defense designed to accommodate First Amendment concerns is notoriously fact-sensitive and cannot be resolved without a trial. Well, we know that all too well. The fair use defense is, yeah. The less bold amongst us would have to think twice before using official legal works that illuminate the law we're all presumed to know and understand. Yeah. Thankfully, there is a clear path forward that avoids this, the one we're already on. Instead of examining whether a given material carries the force of the law, we ask only whether the author is a judge or legislature. If so, then it's not copyright. That framework is established, and therefore we're done. Great. That was simple, clean, easy to understand. Solves a lot of problems. No muss, no fuss. Excellent. Very exciting. All right. So we have Justice Thomas, Alito, and Breyer. Breyer and Thomas together. Interesting. Particularly because I think, if memory serves correctly, Breyer was that dissenting vote in Elred, where he thought the terms had gone too far. So, it's a little bit surprising to see him here, but okay. Well, Justice Thomas, what do you want to have to say? According to the majority, these 19th century precedents clearly stand for the proposition that judges and legislatures cannot serve as authors when they produce works. And after straining to conclude that the Code Commission is an arm of the legislature, I don't know how much of a stretch it is, but okay. The majority concludes that Georgia cannot hold a copyright in its annotations that are included as part of the official code. That ruling will likely come as a shock to 25 other jurisdictions, 22 states, territories, and districts that rely on arrangements similar to Georgia's to produce annotated codes. Well, I don't know if it will or not. Those will have to be adjudicated. But so that's an interesting question. Does the fact that here's an interesting question. Let's put on our thinking hats. Does the fact that Georgia made it part of its official code matter or not? Because the majority seems to think no, it doesn't matter. It just matters whether it was work of it. So the fact that it was part of the official code is actually ultimately irrelevant. So actually, the idea that I had at the top of the stream that Georgia would just say, "Oh, it's not annotated anymore," or "It's not the official thing anymore." Apparently, the majority thought about that because if I read the majority's opinion correctly, the fact that those annotations were part of the official code is irrelevant. It doesn't matter. What matters is that they were a work of authorship of it. So yes, it would therefore follow that all these annotations that are produced by all these other states would likewise fall for exactly the same reason. So, I don't have any objection to that. I think that's fine. I just didn't realize the full scope of that when I first read it because, we never saw anything in the opinion that said that because it was the annotated or because the annotations were official, that's what triggered it. Which for me, what for me was what I was thinking initially. And so that was where I sort of did my analysis, right? Because it became official, that's what triggered it. And so I had sort of said in my own head that if it had not been official, then we wouldn't have this problem. But that's not where the majority seems to be going. So apparently Georgia can't get around this anymore. Anything that they sponsor in this way, and I mean, there might be alternate arrangements that would not trigger this problem. So if Georgia is interested in creating annotations that they pay for that will not be subject to this decision, I think there are alternative arrangements that would allow them to do that. The whole thing that makes this work is that it's this body that is a legislative body, that's doing it, and it has legislation to do it. So if you could avoid that problem, and I think there's ways to construct it that would, then you would be able to keep it outside. And also it'd be interesting, Justice Thomas is saying this as fait accompli. So Thomas is saying that these 22 states and 2 territories and District of Columbias rely on relations similar to. So I don't know that's necessarily automatic that all those become open because you'd want to know just how similar to. Because the way the majority's opinion is resting on that this is being done as a legislative act and rests on the nature of the commission and so forth and so on. So I think that each of those might have to be adjudicated. And it's quite possible that some of them will not come out the same way because of the technical nature of how they're being done. But it's not because it's official or not that is going to trigger it. So that's interesting. So yeah, so maybe there will be 25 lawsuits that will be filed. No, that'd be interesting. Also, it's interesting that in the territories, that's also interesting, and also for District of Columbia, do works of the DC government count as works of the federal government for the purposes of copyright law? I honestly don't know. And also for the territories, same problem, because the territories are under the auspices of the federal government ultimately. So do those count as works of the federal government? I don't know. So the section of 105 qualifies. But yeah, there's some interesting questions there that need to be resolved. Perhaps these jurisdictions all overlook this court's purportedly clear guidance, or perhaps the widespread use of these arrangements indicates today's decision extends the government's ease doctrine to a new context rather than simply confirming what the precedents have already had. Because I believe we should leave Congress to the task of updating this, I dissent. Okay, fair enough. Yeah. Anyways. In Wheaton, the court first regards self-evident judicial opinions cannot be copyrighted either by judges who sign them or by a report under the auspices of who they're published. Congress provided that in return for a salary of $1,000, the reporter of decisions of the court would prepare the reports consistent with judicial opinions. Wheaton, one of the court's earliest reporters, argued he owned the copyright. He contended that he had acquired the right of the opinions by gift, hilarious, once they became part of his volume. The court ultimately remanded on the question of whether he had complied with the Copyright Act's procedural requirements. In doing so, it observed in dicta the court was unanimously of the opinion that no reporter can have any copyright in the written opinions, and that such judges therefrom cannot confer on reports as the right. That's very interesting. So they remanded for a factual finding, and they said, "Oh, by the way, there's no copyright interest in this," as an aside. A very weird way to do it, but okay. 54 years later, the court returned on the same subject, suggesting a doctrinal basis for the rule that judicial decisions and certainly closely held materials cannot be copyrighted. In Banks, the state author published of the Ohio Supreme Court decisions sued a competing publisher. The competing publisher reproduced portions of the works, including the Supreme Court decisions, statements, and syllabus, all of which were originally prepared by the authoring judge. The court held these materials were not subject to copyright. In reaching that conclusion, the court grounded its analysis in interpretation of the word author and anchored this interpretation in public policy. The judge, who is a judge, prepares the opinion, is not regarded as the author in the sense that the Copyright Act is able to confer the assignment, which, I'm totally cool with that. The court has also supported this conclusion by stating there's also been a judicial consensus that no copyright could, unless statutes passed by Congress, be secured in the products of labor done by judicial authors in the discharge of their duties. And Congress observed in this rule reflected in the view that authentic expressions and interpretation of law is free for publication of law, which in turn prevents a judge from qualifying as an author. Welcome, Newt, as a supporter. I am happy to have you. We appreciate your support. Thank you very much. Importantly, the court also briefly discussed whether the state of Ohio could be directly holder of the copyright. In answering this question, the court did not suggest that states were categorically prohibited. Instead, the court simply noted that a state fell outside the scope of the act because it was not a resident or citizen of the United States, as was then required by the statute. So in the old version of the statute, you had to be a resident or citizen of the United States, and states are none of those things. They're not a resident or citizen of the United States. Yeah, no. The court felt it necessary to observe, however, that whenever a state could take out copyright, it could enjoy the benefit as an assignee of citizen of the United States, which could be the author of the work, is question not resolved. So basically what that's saying is, and this is still true today, the U.S. government can hold copyrights, they just can't be the author of them. So if the work gets transferred to them, they can hold a copyright, and same for a state too. So that's what they're talking about, right? So states couldn't be authors because they weren't citizens of the United States, because, they're not. But they could hold copyright if transfer got to them. And same thing for the United States today. The United States can hold copyrights if the work gets transferred to them. So, there's something there. Finally, in Callaghan, the court addressed the limits of the government's edicts doctrine. In that case, the court settled another dispute between the publisher of court decisions and an alleged infringer. The plaintiff purchased the proprietary rights to reporters' decisions prepared by Illinois Supreme Court Reporter of Decisions Friedman, including the copyright to the reports. Unlike in Banks, these reports also contained authors from Friedman. The alleged infringers copied the judicial decision and Friedman's materials. In finding for the plaintiff, this court reiterates there can be no copyright in the opinions of judges or work created by them, but conclude that no similar grounds of copyright justify denying when it's covered matter of which it's intellectual labor. These precedents establish that judicial opinions cannot be copyrighted, but they do not exclude from copyright the notes that are prepared by the court reporter and published together with the reported opinions. There's no apparent why this logic would not apply to statute and regulations. Well, there is a bit of a difference in that in those cases, as far as I'm aware, the person who was preparing the annotations wasn't doing so as a request from their employer. That's the big difference in facts, as far as I understand it. So in those decisions, when those annotations were being made, they're being done by the guy because, reasons. Excuse me 1 second, I have a call. Hold on. Apologize for the interruption. So anyways, as I was saying before I was interrupted, it would matter why they were doing it, right? Because in those old cases, the reporter was just doing it because they felt like it. But in this case, they were doing it because they were being paid and asked. So that's the difference. There's a factual difference that matters here as far as I'm concerned. So like it isn't that, their annotations done by a private party. They're being annotations being done because they're being asked to be doing and as supervised and so forth and so on. So there does seem to be a factual difference here that Thomas is not seeming to recognize that turns this, as far as I can see from the logic of it. So there seems to be a logical error here, because he says no apparent reason why this logic would not follow. There is a logical reason, because there's a factual difference that makes a logical difference. So I think there's something turning on this. It's fair to say the court's 19th century decisions do not provide any extended explanation of the basis for this government edicts doctrine. The majority is nonetheless content to accept these precedents reflexively, without examining the origin of the rule they announce. Okay, fair enough. So they're saying, like, you're not wondering why these precedents are valid, and, normally, like, that's not that big a deal, because, they are unless they're not, right? And there's no reason to overrule them. For the majority, it seems enough that precedents establish a rule that seems too obvious to ignore with further explanation. But the contours of the rule are far from clear, and understanding the scope, we must explore the underlying rationale. In my view, the majority's uncritical exploration of the precedent is inconsistent with the judicial role. Ouch. Ouch. Thomas is calling the majority bad judges. Man, jeez. An unwillingness to examine the root of precedent has led the sprout of many noxious weeds that distort the meaning of the Constitution and statutes alike. Although we have not been asked to revisit these precedents, it behooves us to explore the origin and justification, especially as we're being asked to apply their rule to the first time in over 130 years. Okay. I don't know if they're shadow banning me, man. I don't know what's going on. Nothing. I mean, how much shadow banning can they be when they give me memberships? I don't know. The court's precedent suggests three possible grounds supporting the conclusion. In Banks, the court referenced the meaning of the term author. While the court did not develop the argument, it's conceivable the contemporaneous public meaning of the term was narrower in the copyright context than ordinary speech. At the time courts decided Banks, the Copyright Act provided protection for books, maps, prints, engravings, musicals, and dramatic compositions, photographs, and works of art. Judicial opinions were different from those. Books, for example, expressed thoughts of the authors. They typically have no power beyond the ability of their words to influence readers, and usually are just published at private expense. Judicial opinions, on the other hand, do not express thoughts at the judges who write or endorse them. Instead, they elaborate and apply rules of law, in turn representing the implication of the will of the people. Unlike copyrightable works of authorship, judicial opinions have binding legal effect, and are produced and issued at public expense. Moreover, copyright law understands an author to be a work that will encouraged by the grant of the right, which not so much for judges. The judges, when acting in official capacity, do not fit the description of an author. The court in Banks may have held these differences in mind when concluded it fell outside the scope of author. History also suggests a narrow meaning of author. In England, as far back as 1666, courts and commentators agree the property of all law books is of the king because he pays the judges who pronounce the law. Blackstone described this as a prerogatory copyright, explaining that the king, as an executive magistrate, has the rights promulgating to the people all acts of the state of government. Yeah, this is a problem when you have a monarchy. Yeah, so there you go. UK, you have a monarchy and you should feel bad. Yeah. This gives the exclusive privilege of printing at its own press, or the grantees, all the acts of parliament, promulgations, and orders of the council. History explains the dearth of cases permitting individuals to obtain copyrights, but under the Constitution, sovereignty lies with the people, not a king. Yeah. The English historical practice, when superimposed on the Constitution's recognition that sovereignty rides in the people, helps to explain the court's conclusion that authentic exploration and importation law is free publication for law. Finally, concerns of fair notice, often recognized by this court's precedent, are an important component of due process, also have animated the reasoning of these 19th century cases. As one court put it, the decisions and opinions of the justices are authored expositions and interpreters of the law which are binding upon all citizens. Every citizen is promised to know the law thus declared, and need no argument to show justice requires all should have free access to the opinions, which, kind of goes the other way, man. Jeez. That seems like it kind of goes the other way. Allowing annotations to be copyrighted does not run afoul of any of these possible justifications. Okay. First, unlike judicial opinions and statutes, these annotations do not even purport to embody the will of the people because they are not law. Okay. The General Assembly of Georgia has made abundantly clear through a variety of provisions that annotations do not have any binding obligation. I mean, that's totally true. Blah, 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 blah. As additional evidence, the annotations do not represent the will of the people. The General Assembly does not enact the annotations under its legislative power. To enact it bicameralism, presentment. Yeah. Here's a random trivia question for Matt. I don't really expect you to know this off the top of your head. What state does not have both a House and Senate? Let's see if Matt happens to know that one off the top of his head. It's more trivia than law, but just for shits, let's see if he gets it. Second, unlike judges and legislators, the creators of annotations and incentives by copyright laws to produce a desirable product that will have eventually earn a profit. And although the commission may require Lexis to follow strict guidelines, 42? It's okay, Matt, we love you. The answer, by the way, is Nebraska. Nebraska is unicameral, only has a Senate. And by the commission may require Lexis to follow strict guidelines, the independent synthesis, analysis, and creative drafting behind annotations may analogies to other copyrightable materials. Lastly, the annotations do not impede fair notice of the laws. As just stated, the annotations do not carry the binding force of law. They simply summarize independent source of legal information and consolidate them into one place. Thus, the annotations serve an important function other copyright tools provide by private law. Poor Matt. Matt's a great guy. Matt, for those of you who may not know, is also my editor, so he really helps me out. And I tease. We only tease the ones we love. That's what we're going with. So Matt's help is endlessly appreciated. Thank you, Matt. The majority resists this conclusion, suggesting that he gives me equally back. He gives me hard times. So yeah. The majority resists the conclusion, suggesting that without access to annotations, readers of Georgia's law will be unable to understand the true meaning of the statutory provisions. Such provisions have been undermined or nullified by the correct decisions. This is incorrect, as the majority tacitly concedes a person seeking information about changes in the law could find this information by consulting the official sources themselves and the court decisions. The inability to access this merely deprives the researcher of one specific tool, not the underlying information. Well, I guess it's kind of true, but also whatever. Yeah. The text of the Copyright Law Act supports my reading of the precedents. Specifically, there are 4 indications that annotations are copyrightable. As an initial matter, the Act does not define the word author. According, the term does not suggest any term. While the Act excludes from protection works of the U.S. government, the Act contains no similar works of the work of the state governments, which, at least as far as I'm concerned, should, but, whatever. Third, the Act specifically notes that annotations are... Yeah, that doesn't answer the question. For all these reasons, I would conclude that the privately created works are statutorily at issue are copyright. Okay, and then they're going to get into why the majority's reading of those is wrong, whatever. Blah, 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 blah. I'm trying to get to the next dissenter. Justice Ginsburg with Justice Breyer. What is their rationale? Beyond doubt, state laws are not copyrightable, nor are other materials created by the legislature in the course of performing their abilities. Not all that legislators do is ineligible. When the government edicts doctrine, shows only works that are created by judges and legislatures in the course of their duties. The core question in this case, as I see it, are the annotations done in a legislative capacity? The answer, I'm persuaded, should be no. Yeah. To explain why, I proceed from common ground. All agree headnotes and syllabus are copyrightable when created by a reporter, but not copyrightable when created by judges. Yeah, fair enough. One might ask, if a judge's annotations are not copyrightable, why are those created by legislatures? The answer lies in the difference between the role of a judge and the role of the legislature. To the judiciary, we assign a duty of interpreting the law, and sometimes making the applicable law. Yeah, in Erie, and federal common law. There's not much federal common law, but there's a little bit of it floating around, but not much. The annotations which are not created contemporaneously within statutes to which they pertain. Instead, the annotations can comment on statutes already enacted. In short, annotating begins only after lawmaking ends. And apparently, California is apparently free to create CalFlix because of that earlier decision, right? They can't be sued for copyright infringement. So, you know, they could have CalFlix, I guess. That'd be hilarious. You wonder if they'll get copyright on CalFlix itself. So that's a fun question to contemplate. The annotations are descriptive rather than prescriptive. Instead, a state legislature's perception of what the law conveys, the annotations summarize the writings. For example, this contains annotations for all the statutes of the courts. Third, and of prime importance, the annotations are given for the purpose of convenient reference. The reference to statutory provisions shall be merged does not render the annotations anything other than explanatory reference or commercial material. I think that's a mistake. I think the annotations being merged makes a material difference. Annotations aid the legal researcher, and the aid is enhanced when they're printed alongside. Replacement does not alter their auxiliary non-legislative character. Yeah, I understood, Matthew, when I've figured out what you're meaning. It's like, oh yeah, I figured it out. It took me 10 seconds, but I got there. Because summarizing judicial decisions and commentary bearing on an act of statute, in contrast, for example, drafting committee reports, is not done in the capacity, I would hold them that they're copyrightable, and I would reverse. Okay, great. Well, that's the end of that decision. Fine. All right, great. So that was good. So yeah, apparently, anything that's created by the judicial or executive branch as part of their official capacity, no copyright. And 25 states will soon have, 22 states, 2 territories, and the DC will soon have lawsuits trying to figure out whether or not their stuff is copyrighted under the same logic, depending on exactly how they're being constructed. So that should be entertaining for all that legislation. But the Georgia copyright, including all of its annotations, is a free-for-all. So torrent to your heart's content, because it's legal now. As to this particular thing, not all things. Torrent to your heart's content as long as your heart's content is the Georgia annotated law. Yeah. Now, what is an interesting question and is unanswered by this is whether or not things that have the force of law that are printed by someone else that are not works of the government are also open. And here I'm thinking about all the wonderful building codes and plumbing codes and electric codes and all that crap, all the code enforcement crap. Because usually your insert city of choice adopts the codes as published by some private group because, why not? But then you have to pay, lots of money to get a copy of that. But it is part of the law, right? Because you have to build the building according to that code. So this case does not answer the question as to whether or not that stuff is also free-for-all, which, would be hilarious. So maybe someone will go fight that fight and figure out whether or not that's copyrightable or not. There's a copyright interest there in the work as it originally existed. The state adopts it as part of its official policy. But yeah, I don't know what the answer to that question is. I don't know if the answer to that question is logically or otherwise. I think probably the copyright becomes extinguished and then you have a takings issue. But then again, you can't sue the state for copyright infringement. So that's very sad. You used to have a takings issue until, you didn't have a taking. So yeah, you spent all this work coming up with this really, really wonderful code, and then a state adopts it, and they've basically taken your property, and there's nothing you can do about it because you can't sue them because of that earlier case from the North Carolina pirate thing. So maybe that's a consequence of all this. I don't know. We'll see. But I think that's an interesting question that needs to still be resolved, is the copyright interest in that stuff because it has legal operative effect. So that's a really interesting question to me. That's a really interesting question. So someone who wants to build houses and doesn't want to pay for it needs to sue. It could be fun. The Blackbeard case said there's no takings issue. That's right. It said you can't sue a state for copyright infringement. That was the disposition of that case. Yeah, that was the disposition of the Blackbeard case. It can't sue a state for copyright infringement. So they can take your copyright, and there's not anything you can do about it. Well, in terms of monetary relief, you might be able to get declaratory relief. Maybe. I forget exactly how that case was written, but you definitely can't get money out of them. So, no. I don't think you can even get declaratory relief. I have to reread it. But yeah. El Rio Grande gives me $5. Has anyone really been far even as decide what even go, what look to do? What? Is this a sentence in English? Let's try this again. Has anyone really been far, even as decided to use, even go once, to do look more like? Yes? Thank you for your question. When am I going to do Westboro? It's not on my radar. It's not on my radar of cases to do. So I didn't have any particular desire to do it, but maybe. Yeah, El Rio Grande, you want to give that? You don't have to give me another. You don't have to give me another super chat. But you want to give that question another go, and I assume that Westboro, he wants me to cover like the free speech Supreme Court case from a couple years ago. That would be the Westboro case. I assume he wants me to cover it. It's just not on my list of cases I was planning on doing. But we'll give Rio Grande here a second to type. Old meme. It's a meme. And if it's a meme, it's old. Yeah. Okay. Okay. Know your meme. Let's read about know your meme. Has anyone really been far, even as decided to use, even go want to do more like, is an incoherent question, which is often quoted on image board discussion forums. The question first appeared on a thread of 4chan because of course it did. An anonymous user responded with the question. Several users attempted to decipher the question, speculating that. Okay, so you spent $5 to ask me a question that's purposefully incoherent. Super-tastic. That's just great. I have been trolled by one of my own people who is here frequently. That's super wonderful. That's encouraging news. But I got $5 out of it, so works for me. Yeah. Yeah, that's good times. If you wanna rickroll me, for $50, I will watch your rickroll. That's fine. It's not that bad a song. I'm happy to watch it again. Yeah, I love anything. I love anything that gets me support. That's always a plus. And I believe he's my only super chat supporter today. So that's fine. It wasn't the most exciting stream. That's fine. We'll probably be on later today. No specific time. To discuss the New York State Pistol Rifle Association. It was moot. The issue is it's moot, so no surprise. But there's like 40 pages worth of dicta, which is pretty cool. And so we might read that and try to read some tea leaves. Could be really interesting. So we might do that later today, if we have time. If not, then maybe tomorrow. But for now, my friends, I hope you are well. And talk to you later. And I'll say cheers and goodbye.